In California, a 40-foot move can mean prison. Learn how.
What if I told you that moving someone just 40 feet against their will could land you in prison for 8 years? In California, kidnapping charges are far more common than most people think. They don't require crossing state lines. They don't require a ransom note. In fact, the law covers a much broader range of situations than the public often realizes. Today, I'm going to break down what really constitutes kidnapping in California, what prosecutors have to prove, the potential penalties, and what defenses might be available. Under Penal Code Section 207, kidnapping is defined as taking, holding, or detaining another person by force or by any other means of instilling fear and moving them a substantial distance without their consent. That phrase, or by any other means of instilling fear, is important. You don't have to physically drag someone. You don't even have to lay a hand on them. If you threaten them, intimidate them, or use psychological pressure that makes them believe they can't leave, that can meet the standard for force or fear under the law. Then there's the substantial distance requirement. People sometimes think the law sets a fixed number of feet or miles, but it doesn't. Instead, courts look at the overall circumstances. Did the movement increase the risk of harm to the person? Did it help the perpetrator avoid being seen or caught? Did it give them more opportunity to commit another crime? Moving someone from a public sidewalk into a secluded alley, even if it's just 40 feet, can satisfy the substantial distance requirement because it changes the danger in the situation dramatically. In a California kidnapping case, prosecutors have to prove 4 things beyond a reasonable doubt. First, that you took, held, or detained another person using force or fear. Second, that you moved that person or made them move a substantial distance. Third, that they did not consent to the movement. And fourth, that you did not reasonably believe they consented. Every one of those elements must be proven. If the prosecution fails to prove even one, there cannot be a conviction for kidnapping. Now let's talk about the potential consequences. For simple kidnapping, the penalties include 3, 5, or 8 years in state prison and fines of up to $10,000. But that's not all. Kidnapping is considered a strike offense under California's 3 strikes law. That means if you're convicted of kidnapping and later convicted of another strike offense, your sentence can be doubled. If you already have 2 strikes, a third conviction can lead to 25 years to life. Defenses to kidnapping charges depend on the facts, but there are some that come up often. Consent is one of the most common. If the person agreed to go with you, it's not kidnapping. There's also reasonable belief in consent, where you honestly believe they were willing to go. Another defense is insufficient movement. Maybe the distance was slight or trivial and didn't increase any danger. And then there's the absence of force or fear. Finally, false accusations are not uncommon, especially in heated situations like child custody disputes, where one parent may accuse the other of kidnapping their own child. Things get much more severe when we're talking about aggravated kidnapping under Penal Code Section 209. This covers kidnapping for ransom, reward, extortion, or with the intent to commit robbery, rape, or other serious sex crimes. It also applies if the victim suffers bodily harm or if the kidnapping results in death. For most aggravated kidnapping charges, the penalty is life in prison with the possibility of parole. But if the victim dies or suffers bodily harm, the sentence can be life without the possibility of parole. These are some of the most serious charges in the state's criminal code. To understand how kidnapping charges can arise, it helps to look at real-world situations. Imagine a carjacking where the driver is forced to stay in the car and drive somewhere. That's kidnapping. Or during a robbery, if the victim is moved to another location inside a building to make the crime easier or avoid detection, that movement can lead to a kidnapping charge. And yes, parents can even face kidnapping charges for taking their own children if they violate custody orders. Kidnapping charges in California are complex and the stakes couldn't be higher. The law doesn't just punish the act of moving someone, it focuses on the circumstances, the intent, and the risks involved. That's why anyone facing this type of accusation needs to take it seriously from the very first moment. The earlier you get the right legal guidance, the more opportunities you have to challenge the charges and protect your future. If you or someone you love is facing kidnapping charges, schedule a consultation today. The sooner you act, the better your chances of building a strong defense and protecting what matters most. And if you found this breakdown helpful, make sure to subscribe to our YouTube channel for more legal insights and real-world explanations of California criminal law.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.